Well, folks, we have our first major update in the Destiny versus Pxie lawsuit, and that comes from Pxie seeking some pretrial motions, first to get a temporary restraining order put in place, and second to get a preliminary injunction put in place, both centered around this idea that Destiny is engaged in some bad conduct that, if not stopped, will cause her irreparable harm. And therefore the court needs to step in to order he stop his behavior. But is there any merit to what she's talking about? That's what this video is going to be about. What's up, everybody? Welcome back to the channel. My name is Scotty O, aka the Gen Z attorney, and I currently work as an assistant district attorney in North Carolina, meaning I'm in courtrooms all day, every day. And I use this channel to make videos about real life court cases to really dive in the nuts and bolts and help you understand how the justice system really works. And I've been following this Destiny versus Pxie lawsuit really from the very beginning, from Pxie filing her initial complaint to Destiny making a video where he responds to the complaint. And then my most recent video was about a loophole that might actually save Destiny from the entire case, at least on the federal side of things. And after that last video, I said I wasn't going to touch this case again until we had a major update to go off of, mainly waiting for some actual court proceedings, because I don't play the rumor drama game on Twitter. I actually wait for court documents that I can refer to, since those are the real deal. That's the actual proceedings, the actual developments in the case. And on a side note, the last 2 months I've been incredibly busy. On the one hand, got married, so busy with that. And on the other hand, I'm actually getting a new job. I'm switching over from assistant district attorney to the Air Force. I'm going to be in the JAG Corps, so I'll be a lawyer for the Air Force. Been a lot going on with all that, but in the 2 months I've been dealing with all that, there have not been any updates on this case up until this proceeding. So it actually works out perfectly, and that's what this video is going to be about today, going through the transcript from that court proceeding, addressing the temporary restraining order, or the TRO, as well as the brief that Destiny filed regarding a preliminary injunction generally. We're going to talk all about what those are, what they mean, what they're meant to accomplish, and the strength of the case through this first proceeding, because I think we get a lot of really good information as to how this case is going and how the case might actually get thrown out sooner rather than later. So without further ado, let's just jump right into this thing. Okay, so here we have it. This is the transcript from the court proceeding. Yes, I'm going to be referring to the video that Destiny made on the topic, just since it does have all the documents I'm looking for, and it has him reading through them, and I can put it on a faster speed, 1.25, to get through a little faster. But yeah, we're going to start here with the temporary restraining order, the hearing that was held regarding that, because we have an actual transcript which includes the judge and what the judge was saying in this hearing. And that's kind of step one here. And later we'll get into the preliminary injunction, the brief that Destiny filed, so giving his side of things. And yeah, kind of getting an update on where things stand, because as I understand it, this is the first time they've appeared in court together, all the parties, the two opposing parties, and then the judge, to discuss an issue in the case. And specifically the issue here is that of a temporary restraining order, or I'm just going to say TRO from here on out. A TRO is basically an emergency order that one side comes to the court and says, Your Honor, the other side is engaged in some type of conduct that if you don't order them to stop, I'm going to be irreparably harmed. That's the general gist of why it's a emergency, first off, because it's very time sensitive, time relevant. And it's a restraining order because you're ordering them to restrain themselves from doing particular activity. And it's temporary. That's the T, stands for temporary, because then it'll roll into a preliminary injunction, which would last for the entirety of the litigation process. So the general standard for granting a TRO or a PI is generally twofold. The first prong is that there be irreparable harm that would be suffered if an order is not given, if an injunction is not entered. So yeah, right, the idea of irreparable harm, which, conceptualize it by, once you ring the bell, you can't unring the bell, or once the toothpaste comes out of the bottle, you can't put the toothpaste back into the bottle. So irreparable harm has to be shown, A, and B, there has to be a likelihood of success on the merits of the case, meaning, of course, the jury is going to get the final say on the verdict, the outcome of the case, but a judge can take basically a preview of the facts and decide for themselves, make a determination saying, well, yes, the jury gets the final say, but I can see clearly that one side has a strong claim that they're probably going to win this case. So, and that side is the one that's asking me, saying, hey, can you enjoin this behavior because we're going to suffer irreparable harm? The judge can look at that, look at both those prongs, and then decide to grant a TRO or a PI based on those. So that's where we are here. It is Pxie's side that has filed this motion, and the court scheduled it very short notice because by their very nature, TROs are of an emergency nature. However, the thing about this is this TRO was not filed until April. And the complaint was filed back in February. So here we have a TRO, something in emergency nature that filed with 2 months later, and you filed with facts that are basically the same as what was alleged in the complaint. So I can already see here, this is going to be a huge question for the judge is, why is this an emergency? Why did you make me schedule this so short notice? What has changed from when you filed this 2 months ago to now that requires we have an emergency hearing and I grant this order? So yeah, we're just going to jump right into it and hear what the judge has to say and go from there.
So this case has been pending for a number of months. You looked at me a little cockeyed, ma'am. Didn't you file it a couple months ago? Miss Schlump, February 21st, I believe. Yes. Yes, correct. It's April, so it's been filed. The parties have already met for the joint status report. That was already filed. I got a scheduling order. The defendants have answered. And now, last night, I get a TRO based on facts that don't appear to be any different from the complaint. So I want to hear, just very briefly, as to why I should entertain the TRO as opposed to just setting it down for a preliminary injunction.
All right, and this is exactly what I just referred to. It's this judge has received this motion for TRO, and basically think of it like there's alarm bells going off, there's sirens, wee woo wee woo of this is an emergency. We have to address this. We have to hear this as soon as possible. Judge, we need to be in your courtroom ASAP. This is an emergency. And so the judge is like, okay, I'll schedule it, and it gets scheduled, and they meet, and now the judge is here and is like, I see what you submitted, but you submitted something that's basically the same thing that you submitted 2 months ago in your complaint. So where's the emergency? Please, this is the very first question the judge is asking. Can you tell me, what are we doing here? What is going on? Why did you want to schedule this so badly? Please just give me some sort of inclination, some sort of inkling of what we're doing here. And so that's the very first question out the judge's mouth.
Plaintiffs say, well, Your Honor, I do apologize for the delay in getting that motion out. There are a number of reasons why that happened. One, and I hate to go into personal things, but Mr. Garcia was dealing with a cancer issue and going back and forth to Texas. I had pneumonia, and I was out straight for more than 2 weeks, so we were really set back. There's just two of...
Yeah, fair enough. Health issues, they occur, so that can certainly explain some of the delay in this situation.
There's also other reasons, which is that we were trying to gather affidavits from witnesses to bolster our evidence for the TRO and get, witnesses lined up for it.
Okay, and this is... So all right, okay. The delay, they're explaining away this delay with two different arguments. First, health issues. Okay, fair enough. We can give you some leeway with that. But second here, delayed in filing for a TRO because you didn't have all of your witnesses together. You didn't have all your evidence lined up to submit to the court. And that's why you were delayed. But that's immediately, you're begging the question now. If you didn't have all your evidence together, why'd you file the complaint in the first place back in February? Why not wait until you have your evidence lined up and then file the complaint? Why are you filing something while you're still gathering witnesses, gathering evidence? That's immediately, you're begging the question now from the judge, and we'll see if the judge asks it.
Unfortunately, what we have encountered, we have a number of women that have come forward to us, but have then backed out because they are afraid of retaliation. And that's what they've told us, and so we were not able to get these affidavits. Okay. We went with what we have now, which basically we went from 15 potential witnesses providing evidence down to the one witness in addition to the plaintiff. Okay. That doesn't have anything to do with anything. This is not a class action. You filed on behalf of one woman. The TRO requests that he remove the video of the one woman, and then there is a request with respect to whether or not he's doing anything to destroy evidence in this case. I don't know that that's a TRO. I think that's more akin, you can file a motion with respect to that. None of this sounds in a TRO to me. So...
Yeah, so, okay, we've got more of the explanation, which is that we've got witnesses that are backing out, and sure, I don't have any reason to dispute that, but you're still at the point now, you're filing for a TRO, and the judge calls it like it is, so that doesn't have anything to do with anything. You're filing on behalf of one plaintiff, which is Pxie, and your TRO is requesting two things. You're requesting to remove a video about Pxie, and then order Destiny to stop, or order Destiny to not destroy evidence. But that second prong is, well, the first prong regarding Pxie, it's like, yeah, okay, fair enough. But the video regarding Pxie, that has nothing to do with, you've got 15 witnesses that you're talking about. Unless you can make some connection to why they have to do with Pxie, that seems irrelevant. And then to the second point about destroying evidence, yeah, and the judge says, so here, you can file a motion with respect to that. That motion would be called a spoliation motion. And spoliation is the idea of destroying evidence. And a motion to address spoliation, that's where your remedies are really available. You don't have many remedies to address the destruction of evidence through a TRO or a PI other than to order they stop destroying evidence. But there's already a duty to not destroy evidence. The complaint puts you on notice to preserve evidence. They sent a preservation letter to preserve evidence, and the TRO has been filed. So there's just so many levels of notice. The duty to preserve evidence is very evident and apparent. If you can provide evidence that they're not following that duty, then sure, present it. Let's hear it. But they're already under an order to preserve evidence, or at least a duty to preserve evidence. But now you want to supplement that duty with a court order to preserve evidence. It's kind of redundant and not really grounds for a TRO. Instead, that would be right. You would address that through a spoliation motion, but they didn't do a spoliation motion. They did a TRO. So already, yeah, Pxie's team is not really making a whole lot of sense, and they're really not presenting well. The judges, like I said at the beginning, the judge is already on guard of like, okay, you filed this motion, you said this is an emergency, what's the emergency here? And right out the gate, Pxie's team really does not have anything to offer the court that would be satisfactory.
I don't see the emergency nature of the TRO. This seems to me, at best, a preliminary injunction. There's nothing that's happening today that wasn't happening when you filed the suit or even a month before, right? In fact, if anything, like the dates seem to line up sometime at the end of the year, right? I'm in April. I don't see why the request for a TRO is not stale.
Yeah, this idea of something being stale is also super important. This goes to ideas of standing, where issues can be, if they're ready to be heard by a court, they'd be considered ripe. But if they're past the point where they can be heard or should be heard, then the issue would be considered moot. I've always heard that word moot is the word. I've not heard stale used, but it seems to be the same. It's doing the same thing here, saying that you're past the point where a TRO is applicable, because the fact that you waited 2 months kind of negates your argument that this is a big emergency and you need an emergency or a restraining order put in place right away. And because you don't really have much of an emergency going on, nothing has changed in these last 2 months, then your argument is stale at this point.
I agree that most of the damage has already been done, but the issue is that we keep receiving evidence of destruction of evidence. We are trying to compile enough evidence to file a motion for spoliation because we are very concerned with the fact that all of this evidence is disappearing. So we are hoping to file that very shortly. We're waiting for a specific piece of evidence that we wanted to bring before the court.
Well, now, so which one is it? Because weren't they just saying that we're still gathering evidence, so we had to wait. So wait, which one is it? Because weren't they just saying that the reason they had to wait 2 months to file for the TRO was, well, we were still gathering evidence, and so we didn't want to file until we had our stuff together. So that's why we were delayed. But now they're simultaneously saying, but also we haven't filed a motion yet, a spoliation motion, because we don't have enough evidence. So they're simultaneously delayed because they're waiting on evidence, but then they filed while they're still apparently waiting on more evidence. Like, yeah, it seems like they're trying to argue two contradictory points here that, yeah, it's just, this is not adding up at all. Like, Pxie's team right here is completely nuking their own credibility as competent lawyers or good faith officers of the court. At least that's my reading on this. And so, yeah, I don't really know what they're trying to get at here. And it seems like the judge is not buying really any of it either.
So yes, I agree with you. This is not an urgent matter for having a TRO immediately, but it is ongoing harm that we would like to stop.
So you just agreed that this is not an urgent matter that needs a TRO immediately? You just conceded that it's not an emergency and conceded you don't need a TRO. So why'd you file for a TRO in the first place? Yeah, like, this is exactly what I'm talking about. They're coming into these arguments with completely contradictory arguments, or as soon as they're getting any pushback from the judge, they're caving, like, oh yeah, maybe there's not really an emergency. But I don't know. It just seems like they really don't have a plan. Like, this feels like the Disney Star Wars sequel trilogy. They're just flying by the seat of their pants with no plan in place and just kind of taking things as they come. And that's not the way you win in federal court. And this judge is, I wish I could have been there and watched this, because I have to imagine this judge is not happy at all with them.
I'm here Wednesday, but I start a criminal trial on Thursday that's likely to go for a week. And so my intention was to deny your request for a temporary restraining order, but set a preliminary injunction hearing and refer that, though, to the magistrate judge, who's got, he doesn't have my trial schedule, so he can hear the preliminary injunction.
So this is the judge basically saying, and this was funny too, we haven't even gotten to the point of Destiny's lawyers saying anything. This is all Pxie's lawyers that the judge has been grilling, and the judge has now said, my intention is to deny your request for a TRO and set it for a PI. And as Destiny's lawyers, you're sitting pretty right now, because all you had to do was appear, and you're just sitting there, and the judge is grilling the other side, and the judge has already denied their motion, or was saying at this point, intending to deny the motion, and you haven't even had to argue your side or your defense at all. You just had to sit there and look pretty. So But yeah, and it seems right. They really had no argument to begin with. But from what the last thing they said about, yeah, we agree it's not an emergency, sounds like they knew they didn't really have an argument either, which begs the question once again, why did you drag everyone into court, especially on such short notice? This is just such a bad look for Pxie's team.
I don't know, it's a spoliation issue even, right? At least how you've pled it so far, or how you've argued it so far. So I called you in for the status because I didn't know if there was something else that was happening with respect to the timing for the TRO. I'm assuming that you've also been talking to counsel because you were together for the joint scheduling report. Correct. And then Andrew says, my lawyer, sorry, Your Honor, we were shocked to hear about this. And then the judge responds, sir, I'm talking to counsel for plaintiff. I will get to you.
Okay, I'm sorry, that's just funny because, right, never interrupt your opponent when they're making a mistake. That might be a Sun Tzu quote or something like that. But yeah, that's Destiny's lawyer right there, trying to jump in. Sorry, Your Honor, we were shocked to hear about this. Sir, I'm talking to counsel for plaintiff. I will get to you. Yeah, but yeah, okay, fair enough. Please continue your grilling of the opposing counsel. Yeah, and sometimes it is kind of hard to tell when it's your turn to talk in court, and sometimes you may think it's your time, or you might want to throw in a comment like that, but the judge will be quick to dress you down and be like, nope, I'll get to you. I'm talking with them. And so, but yeah, as to what was happening before that, talking with opposing counsel, right. In federal court, there's a huge component of it, which is all about this idea of the opposing parties, the lawyers need to meet and confer. It's this idea of meet and confer where the court's time is very valuable. And if you're going to schedule something in court, it better be for a dang good reason. Because outside of that, there's an expectation that the parties will meet and confer outside of court to solve whatever issues they can solve. And then when an issue cannot be solved, then you bring it into court and the judge will solve that issue. And yeah, it's a huge expectation just because the court's time is so valuable. And if it's something like you want to come into court to set a time for a hearing, it's like, okay, you don't need to do that. You can do that as the parties outside and then work with the judge's secretary, set a time in court that works for everybody. So this is the judge here who's kind of like, what are we doing? Why are we in court? And you guys have been meeting and conferring, right? And you've been talking about this kind of stuff, right? And I'm assuming you talked about this TRO, right? And then Destiny's lawyer jumps in and is like, actually, no, they did not mention the TRO to us. They just dropped it on us out of nowhere. So this is definitely, and while it may not be a complete requirement that you have to meet and confer for a TRO, because by the emergency nature of it, sometimes it may just need to get filed ASAP. Fair enough. But they've already met and conferred about several different things. And the fact that Pxie's lawyers didn't even mention at all that they were planning on filing for a TRO, it just speaks very badly on Pxie's lawyers and how they're handling this case. It's just completely nuking their credibility, in my opinion.
Yes and no, we did not discuss a motion for TRO during the joint scheduling. We just discussed scheduling.
Yeah, that's just so bad. That's so bad. You're already meeting and conferring to discuss different things, and you're not even going to mention this TRO. Courts really try and avoid trial by ambush. That's why the TV shows are not that accurate, where it's the surprise witness that just shows up in court. Trial by ambush is very frowned upon in the practice of law. And while this is not trial, certainly this is pre-trial, still, same principles apply. We're trying not to surprise people to the best of abilities. And so, yeah, the fact that Pxie's lawyers just did not even mention this is just so bad.
She says, so I'm going to deny your motion for a TRO. I know I just set it for status, but I don't want to have to set the TRO for Wednesday to tell you what I'm telling you now, because I don't think I've read your papers. I think based on your papers, the TRO is stale. But unless I hear an objection from you, not that your objection would necessarily change my mind, but I'm going to let you put the objection on the record if you have one, but I will deny your TRO and set you to go to Judge Torres to have him set the hearing for the preliminary injunction.
Yeah, so there's the official ruling. The judge has made the ruling denying the motion for TRO, believes the TRO is stale. I think that's the correct ruling. You are claiming that there's an emergency, even though it's the same facts on the ground in the 2 months that have happened since the filing. So there's really nothing has changed. There's no emergency. Even in this court hearing, you conceded, yeah, there's really not an emergency. Nothing has changed. So the issue is stale. There's no grounds here for TRO. And the judge is correct in denying this motion. And counsel is not, Pxie's lawyers are not off to a good start. Not off to a good start at all. And if you're Destiny's lawyers, oh my gosh, you're so happy right now. You're just sitting so pretty because you're just like, man, They've been they just made a fool of themselves. Like, that's this entire hearing. All it's been so far is Pxie's lawyers making absolute fools of themselves in front of the judge and just absolutely destroying their credibility. So, yeah, as I said, never interrupt your opponent when they're making a mistake. All Destiny's lawyers have to say right now is, no, yep, we're good, Your Honor, nothing further. Thank you for your time. But it looks like he's got some commentary he wants to throw in, maybe a little salt on the wound, a little insult to injury towards Pxie's team.
We have no objection, Your Honor. All right. And the judge says, all right, now, sir, I can hear from you. And then my lawyer responds, I'm sorry, Your Honor, with the court's ruling right now, I don't think that there is any reason for us to argue any further. I will point out no one is destroying evidence. I will further point out that we had no meet and confer efforts with plaintiff's counsel about this. We were stunned to see not only one, but two motions it looked like for a TRO filed yesterday. And I understand that counsel did say that they didn't file it as an emergency TRO, but by its very nature, TROs are an emergency, seeking emergency relief. This is my understanding. I don't know what an emergency.
So yeah, the beginning, right? So, with the court's ruling right now, I don't think there's any reason to argue any further. Yeah, that's the good feeling of all I had to do was appear in court, and then the judge grilled the other side and then denied their motion without ever hearing from me. That's you won the battle without lifting a finger. That's a good place to be. All this stuff is just additional, maybe trying to garner some more credibility with the judge or advocate for your client. And since they did come in and say Destiny is destroying evidence, and then they go in and like, well, no, he's not, or at least from their side saying no, he's not destroying evidence, and also pointing out that there was no meet and confer, there was no communication at all about this TRO, which is just once again playing poorly or playing into the poor communication, the bad faith. Well, maybe not bad faith, but the lack of good faith. If you want to call that bad faith, fine, but I'll just say a lack of good faith efforts to negotiate with Destiny's counsel.
I mean, it is a little odd, man. I will just say, if you're sitting talking about the schedule and everything, clearly you were already working on the TRO. Probably the defendant didn't love to get that TRO filed, like the day after you were conferring for an hour on the schedule. It doesn't mean you couldn't do it. It's just that it's not great.
So yeah, so it sounds like the timing on that is going to be they did a meet and confer Wednesday, because this hearing's on a Friday. This transcript is from a Friday. The meet and confer on schedule happened Wednesday, and then Thursday night at like 8 or 9 p.m. they filed the TRO and set the hearing for Friday at like 4 p.m. So yeah, to do the whole hour-long scheduling conference and to not even bring it up. And this is the judge. This is the judge that's calling that out and saying, yes, maybe there's not a requirement that you need to meet and confer. However, it's still something you should do because it's just a good practice. And the judge doesn't want to hear stuff that can be resolved out of court. If you can resolve it through meet and confer, that's what the judge wants to care about the most, is that stuff gets solved outside of court, so she's not being brought stupid stuff and stuff like this, so she doesn't have to grill the lawyers. And maybe Pxie's lawyers learned a lesson from this hearing with how much they were grilled, but I guess only time will tell as far as how the next hearing goes.
Their lawyer says, I hear what you're saying, Your Honor. The judge says, it's not a great way to start a case.
And there it is right there. It's not a great way to start a case. And I couldn't agree more. And with all this said, right, we're bashing on Pxie's lawyers and whatnot, but even through this terrible appearance, I mean, okay, NBA playoffs are going on right now. You can have a bad game. You can have a bad game one. Your team could still come back and win the series. But in this case, Pxie could still win the case. Just because, your application for a TRO gets denied, by no means does that mean you're going to lose the case. It's just, but as the judge says, yeah, definitely not a great way to start the case.
These things I know are moving targets, but it's always productive to talk. And let me just say one more thing, because it's day, not day one, because it's day, not day one, because you filed in February, but we're really early on in this litigation that will be before me for God knows how long. You need to confer. Mm-hmm. They respond, understood. The judge says, and you need to confer a lot. I think good lawyers working in good faith can work a lot of things out. And when you can't, that's my job, and I'm happy to hear disputes. I obviously love it, otherwise I wouldn't want this job, but the dispute is better, and it's easier for the court, and it's fairer for the parties if what's before the court has really been crystallized by conferral.
Yep.
Sorry.
Yep, and it's just the judge continuing to grill Pxie's lawyers about this obligation they have to meet and confer with Destiny's lawyers. Even if, they're not going to get along, they're probably not going to see eye to eye on a lot, but at the very least, when you meet and confer and you figure out where your issues are, you're crystallizing the issue. So that way when it's brought to the judge, the judge is the referee here. When it's brought to the referee to decide how something should happen, the issue is crystal clear, but you only get that way through good faith efforts to negotiate and solve things outside of court. And up to this point in this case, it seems like there's been very little attempts to solve things outside of court.
So I hear you that these lawyers aren't going to agree with you, probably on much when it comes to the substance, but it does help to crystallize the issues if you at least talk to each other. And it's very difficult when they've been sitting with you for an hour talking about the schedule and you never mentioned the TRO and it gets filed. It doesn't help in terms of the lawyers trusting each other to at least bring issues in good faith.
Yep.
It's a complex case. I understand, it's a sensitive matter for your client. I understand that. But if we want to go forward in a way that's productive going forward, I'm going to encourage you as best you can to talk to the lawyers. Keep talking to the defense lawyers. And I'm not telling you to agree with them. I'm just telling you to work in good faith to try to bring things to the court when they have been crystallized and when they have been vetted by both sides. I think that only helps the court, and I think it only helps the parties. So, as I said, for purposes of my ruling, I find that the request for a TRO is stale. There's no urgent issue before the court. It can be handled at the preliminary injunction because of my court schedule and trial schedule. It will be referred to the magistrate judge. I would expect that by Monday, his chambers will reach out to you by order or by phone or something, or Tuesday to maybe figure out what those dates are and what the scheduling is.
And that's it. And that's another sign of a good lawyer. They just had this hearing. It lasted 15, 20 minutes. The judge ends it off by recapping. Here's my ruling. Here's why. And here's the next steps. It's just a good sign of lawyering to be able to recap effectively and succinctly, but also before that recap is just more beatdowns regarding the necessity of meeting and conferring. But yeah, that's really it. That wraps up the hearing in front of the judge, and right, off to a terrible start for Pxie's side. When you're in federal court, especially when you're in any court, your credibility with the judge really matters. It may not decide the case. It may not be the deciding factor of a case, but it can really boost up your ability to try the case, or it can really weigh down your ability to try a case if the judge finds you to be a smart, competent, effective litigator, because they know they can trust you and they know you're doing what they want you to do, basically, or at least within the bounds of the rules. If you're constantly going outside the rules, you're trying to bend the rules, break the rules, at least not even maybe the legal rules, but just the commonly understood, like how these things are supposed to go. Like, you should meet and confer. Maybe the rules don't require you to meet and confer before filing TRO, but in this situation, you should have, and you should have. So that's like a kind of an unwritten rule that they broke. Like, yeah, it's really, really hurting your credibility, and to have this type of performance in front of the judge is really not good for Pxie's side, and it's really good for Destiny's side. And so, yeah, that's really it for the transcript regarding the temporary restraining order, the TRO. It's not a good look, not a good showing in front of the judge, and especially when your credibility matters so much as a lawyer, especially with particular judges. And Pxie's lawyers just came off so poorly, and the judge had to really grill them to let them know they're not off to a good start in this case. And so the judge denies the TRO. The judge then sends the application to a magistrate to hear on a preliminary injunction. And the magistrate apparently allowed time for both sides to write briefs in support of their side of the PI. So Pxie is the one requesting it, saying, yes, we need a preliminary injunction to enjoin Destiny from engaging in behavior that is harming our client. And Destiny's side of it is the opposite, saying we don't need to enter a PI. And there's a lot of different reasons he gets into, but and I won't go through all of them. I really just kind of want to go through this beginning here, because it makes a little argument about the federal law in question here and whether or not that law is applicable. If only there was a YouTube lawyer who made a video, maybe about 2 months ago, where he was saying that Destiny might get away with everything because the federal cause of action in question here was not actually effective at the time that he sent the video to Rose, saying that the statute had not gone into full effect, and therefore there is no federal jurisdiction over this case, and therefore the case needs to be dismissed entirely. If only we knew of a YouTube lawyer who pointed this out 2 months ago. But anyway, I'm getting ahead of myself. As I said, this is Destiny's brief, his side opposing a PI, and the very opening of it talks about jurisdiction. So let's see what his lawyers have to say about whether or not this court has federal jurisdiction in this case.
As a threshold matter, the court lacks subject matter jurisdiction here. Threshold matter means, does it meet the bare minimum to do a thing? It has to meet this thing for it to be considered or whatever, right? As a threshold matter, humans have to have DNA or something, right? The court lacks subject matter jurisdiction here. So this case was filed in a federal court. because one of the causes of action is referring to a federal law, right?
Federal question.
Count 1 of the complaint for violation of 15
Real quick, subject matter jurisdiction. To get into federal court, the federal court has to have jurisdiction. Specifically, has to have subject matter jurisdiction. The way federal court can get subject matter jurisdiction, two different ways. One, diversity jurisdiction, meaning the parties are from two different states. So if Destiny lived in New York and Pxie lived in Florida, she could sue him in federal court because the domiciles are different between New York and Florida. Federal court can then step in and hear the issue because of diversity jurisdiction. That's the one way you can get into a federal court. The other way is federal question jurisdiction, and that's what we got here. Basically just saying, is the law in question that's been violated, is it a federal law? Super simple. And right here, yeah, it's 15 U.S.C. 6851. That is the federal law, the federal cause of action that was cited in the complaint. And because of that, that does give the court federal question jurisdiction, and therefore jurisdiction to hear the case. However, as I said in my legal loophole video, the federal law here was likely or potentially not in effect at the time that Destiny sent the video to Rose. And if the federal law was not in effect at the time, that means there is no federal question jurisdiction, and the federal court cannot hear the case. They have to dismiss it. And because of that, there was only, of the 4 causes of action, the first one was federal, the other 3 were state causes of action, and the only reason those were in federal court was because of what's called supplemental jurisdiction, which basically just allows you to staple on state claims with a federal claim just for judicial efficiency. To say, the federal court will say, okay, we'll hear all of it together. We're not going to split this into 2 separate trials, 2 separate cases, one federal case, one state case. Just for judicial efficiency, we're going to hear them all together, so long as the supplemental claims are transactionally related to the federal claim, in which case, here they are. But if the federal claim gets tossed, then there is no longer a federal hook to keep the case in federal court. There's only state claims, and the federal court cannot hear exclusively state claims unless we're talking about diversity jurisdiction, which is not what we're talking about here because they both live in Florida. So with a case that relies solely on federal question jurisdiction, if the sole federal question in the case gets tossed, then the state claims can no longer stay. Those have to get tossed with it. Granted, they can still get refiled in state court, but at the very least, the federal court will no longer hear the case. And so yes, as a threshold matter, saying the court lacks subject matter jurisdiction based on the statute not being effective.
USC, section 6851, is the sole basis for federal question jurisdiction, yet count 1 is fatally flawed because the alleged violation preceded the effective date of the statute by nearly 6 months. So one of the big issues with this is when they filed their case against me, I think they knew that it was out of range for the civil cause of action that they're citing here, but they lied about the date on the DM. They switched the day and the month to try to bring it in range. But the issue is that that's not true. And the issue is that if that message date is wrong, and it is what I say it is, and I know it is what I say it is because I have all the logs, what would happen is the first federal cause of action here, the only federal cause of action, would be invalid. It'd be a failure to state a claim. It wouldn't survive a summary judgment. And if you dismiss the first cause of action, then the entire case is dismissed because it falls out of federal jurisdiction. They would have no.
So Destiny is right about almost everything he just said. The only thing he was wrong about was summary judgment. What he's talking about here, though, is just a motion to dismiss. And he actually stated the language, which was failure to state a claim. That's called a 12B6 motion to dismiss. It's under the Federal Rules Civil Procedure, Rule 12, subsection B, subsection 6, which provides for the dismissal of a lawsuit for failure to state a claim upon which relief can be granted. And although they're making this argument here, which I think is an accurate argument, and he's stating there's been some legal gamesmanship to be nice about it. He called it lying, which may be more accurate, but I'll call it legal gamesmanship to switch some dates around to try and get within the range. Assuming it falls outside of the effective date, and statutes are not retroactive. They do not go back and apply to conduct that occurred before the effective date. And so with that in mind, this case should be dismissed. Now, granted, it would not be dismissed based on this document because this document is just talking about a preliminary injunction. The only issue before the court here is whether or not the court should grant or deny the motion for a preliminary injunction. What Destiny's side is arguing, though, is that basically, yeah, as a threshold matter, this court doesn't even have jurisdiction to hear this case because the federal law was not effective at the time of the offense. And note, too, how he's no longer denying that, basically, yeah, he's not denying that the message was sent. He, in his initial response video, he played very coy with whether or not he actually sent Rose this video. Now he's basically admitting it, but he feels comfortable admitting it because he knows it's outside the range, and the federal statute went into effect after he sent the video and therefore does not apply. So yeah, while this is not the stage in which the case would be dismissed, this would be the argument that is used in order to get the case dismissed. And I have to imagine, honestly, I actually don't even know why they haven't filed this already. Seems like this would be the first thing I'm filing as Destiny's lawyer. Is I'm filing 12b6 motion to dismiss for failure to state a claim because the law doesn't apply. The fact they haven't filed that yet is a little odd. I don't know. Maybe there's an explanation I just don't know about. But at the very least, though, right, it is the same argument. Well, it's the same argument that I made 2 months ago that they are now copy pasting into their PI response, which I mean, I'm not going to take credit for it, but maybe just a coincidence. No, just kidding. I'm sure they would have caught this. In fact, it was a commenter that pointed out the argument to me. So shout out to that commenter for pointing out the effective date of the statute. But yeah, no, I just wanted to touch on that real briefly regarding the preliminary injunction. It goes on to talk about irreparable harm and how, they're really just kind of what they're asking for doesn't really meet the standards for what is needed to grant the PI. But you can go and watch that yourself if you like. That's all I'm really going to talk about for this video. Because as you can see, that's it really. That is the outcome of the first official day in court. A lot to take away from that. The judge is not impressed with Pxie's side. Destiny got a big win without even lifting a finger. And now in the PI, the argument regarding the PI, they've kind of given us an insight, a window into what their next step is going to be, which is going to be filing one of these 12b6 motions to dismiss. And once that's done, Pxie might refile in state court if the federal case gets dismissed. I think that's unlikely because the 3 state claims, those have an element of maliciousness to the conduct. And while what Destiny did is certainly, I'll say, not okay, I think it's hard to prove that what he did was malicious. It sounds like, well, as he says, he's a grade A gooner, and he just gooned too hard, and sending these types of videos to different women as like it's basically sexting, it's flirting, and that's what he was doing. And so, what Pxie would have to prove that he was maliciously sending videos of her in order to embarrass her under the state claims. Under the federal claim, all they'd have to prove is that he was sending videos of her without her consent. Basically, that's the gist of it. And I thought they could have easily proven that, but that's only if the federal law actually applies. If that law doesn't apply, it's going to be incredibly difficult, if not impossible, to prove any level of malicious intent to do so under the state claims. And with all that said, the Destiny cooked meter currently sits at a 1 out of 10 because by my reading of it, I think he's going to, I say get away with everything because I think we can all recognize that certainly what he did was not okay, and maybe there is other litigation to be had with some of the other women. I know Sherry said she filed a police report. I don't know any update on that, if there's any criminal charges that are pending, but certainly regarding the civil case involving Pxie, this is not it is going nowhere fast. In fact, like I said, my official prediction right now is it's going to get dismissed. It's going to be totally thrown out of court. It's not looking good. So that's really all I've got for this video. Went a little longer than normal, but there's a lot of good stuff to dive into with the official court proceedings. Like I said, I don't like dealing with the rumors and the drama and whatnot on Twitter. I like going off of official court documents, and that's what we did today. So if you like this video, then be sure to drop a like down below. If you learned something new, drop a like, or if you like this kind of content, then subscribe to come back for more. I will definitely be following this and anticipating that I'll be making at least one more video on this when it does get dismissed, addressing that argument, just to prove I was right, called this all the way back in February, that this is probably going to get dismissed. But But yeah, so like I said, if you like this kind of content, subscribe, come back for more, get all the updates. And most importantly, what I love the most is the comments. So leave a comment down below. Let me know what you think about this case and how it's developing. I love talking with y'all down in the comments. I will be down there chatting with whoever stops by. So looking forward to that. And I'm hoping to be making more videos once again as my schedule has calmed down a lot. And at least until September. Then yeah, we'll see what happens from there. But thank you all for watching, and I look forward to seeing you all on the next one.